Hello, Wayanad Literature Festival. ഞാനൊന്ന് മലയാളത്തിൽ തുടങ്ങാം. ഈ പാനൽ ഇസ് ഗോയിങ് ടു ബി ഇൻ ഇംഗ്ലീഷ്. പക്ഷേ ബേസിൽ ജോസഫ് എന്ന് പറയുന്ന ഒരു റോക്ക് സ്റ്റാർ വയനാടിൻ്റെ സ്വന്തം നടന് ശേഷം നമ്മൾ ഇട്ടൊരു പാനലാണിത്. But here, for people in Wayanad, I have brought a panel that is rock star in every other any other name in the legal world. You have here the second senior most judge of the Supreme Court who have left an impact on judiciary after Justice H.R. Kania. The only Supreme Court Chief Justice whose portrait only Supreme Court Justice who didn't become a Chief Justice but still has a portrait in the Supreme Court of India is Justice H.R. Kania for the kind of legacy he left behind in that court. I think a second senior most judge in the Supreme Court after him who will command such kind of respect and position is here with us in Justice Chelameswar. Joining him along is Advocate Shyam Divan. When Mr. Shyam Divan gets up to represent you, you have almost won your case. You have for sure won your case in the Supreme Court of India. That is the kind of impact and the legacy that the man leaves, stronger than all the weight that the bar can put. This one man just packs all the punch, and we have got him here at Wayanad Literature Festival to talk to you. And joining him is India's best legal academic today, whose conversations, whose engagements with society, legal world has left its own mark. If you haven't listened to a Mohan Gopal lecture in your life, you are missing a certain kind of understanding on Indian Constitution. And that's the kind of legal academic we have here joining us in Professor Mohan Gopal. So what I want to tell you is that when we invited Basil told us, I can't do serious conversation. This platform is not for me. And we said, we want a fun conversation. And here, right after him, we are getting you a panel with all the gravitas that you can find in India. Law is one of the most difficult, toughest subject for us to understand. Constitution is what holds us together as a democracy, as a citizen of this country. And these are the people who safeguard that huge institution for us. So let's hear from each one of them. I open this session with... No. Okay. So this is how I get schooled on the stage. So Justice Chelameswar corrects me that H.R. Kania is not the only non-CJI portrait in there is H.R. Venkatesh too there. So this will keep happening because put together, we are discussing the 75 years of the Supreme Court, but put together, they have an experience that goes beyond 75 years here. Maybe I'm sure I'm not wrong on that number. So you can all sit and watch me getting schooled by the best in law here. So let me start. When 75 years back, when India dreamed of independence, India dreamed of a court by its people, for its people, to stand up and be the biggest provider of justice for it. And justice is what holds a place together. Unless you feel that the country and its constitution, which we are the country that follows the Indian constitution, values us and gives us an equal right and an equal treatment, a rule of law cannot be there, and without a rule of law, you cannot have a society that can function. So let me open up with asking Justice Chelameswar, what does it mean to be the Supreme Court of India? We hear it in numbers, 80,000 cases pending in the Supreme Court, monthly disposal rate of 5,000 cases every year. Today we have, in the last few years, we have a 30 plus Supreme Court judges put together who sit in multiple panels. So whereas in other countries across the world, the Supreme Court sits as a single bench. In India, it sits as a multiple bench. So there are ways that they talk, say decisions that contradict each other, different kinds of judgment. What does it mean to be the Supreme Court of India today?
I'm sure I'll be trolled now for continuing to bring the Supreme Court to disrepute. But in one word, it means chaos. It simply means chaos. 80,000 cases in the highest court. 80,000 cases in the highest court. God alone knows how long the court will take to solve all those cases or decide all those cases. And I doubt very much whether they'll ever be able to decide all those cases. Even if the pending cases are disposed of after 50 years, cases keep getting added to the Supreme Court registry. The problem is somewhere else. I never understood this as to why the highest court of the land should hear a bail petitions. Bail is a very important aspect of liberty. I am not disputing it. I have no doubt about it. But point is, should it really go up to Supreme Court? Then there is something wrong with the system, not with the court or individual judges. If the principles on which bail is to be granted or refused are very clear, the clarity is to be given by the Supreme Court once for all. Afterwards, cases need not go up to Supreme Court. High Court should be perhaps a luxury. It should end with the District Court. But over a period of time, it so happened, in fact, I was surprised when I went to Supreme Court in 2011, first week, I knew it. As a practicing lawyer, I knew all these things were happening, but then experiencing it from the other side of the bench, of the bar rather, I was sitting with another senior judge who eventually became the Chief Justice of India. And on a Monday morning, there were about 6 bail petitions before us, my first week in the Supreme Court. I felt very uncomfortable. I told the judge, my senior judge on the bench, who was presiding over, I said, brother, I had been the Chief Justice of 2 high courts. Normally, bail applications are assigned in the roster by the Chief Justice to a judge who is relatively new. I wouldn't like to use the word junior judge because now I'm not very comfortable with that. A relatively recently appointed judge, preferably coming from service, not directly elevated from the bar. This is the practice in various high courts with which I was associated. And then, from the Chief Justiceship of Kerala, I go to Supreme Court. Next morning, I sit with another senior-most judge of the court who was scheduled to become the Chief Justice. 2 people hearing bail application rejected by a district judge in Kerala. I mean, it's a weird system. And with this kind of a system, I don't, honestly speaking, I may be corrected by Shyam or Professor Gopal, I don't see any possibility of these 80, the number getting reduced. No, some cases might get disposed of, some more cases come and get added to it. But then we have to, and then we want to, this is a topic on which I can speak for days. For easy reference, since I don't want to take much of time, on this very topic, in 2015 or 16, I had the honor of delivering H.R. Khanna Memorial Lecture in Delhi. This was the topic I chose for the day. It's published. SEC published it. You can kindly go through it. I analyze what's all happening and why this is happening. Court sitting in multiple benches. What is the effect of it? These are all problems which require a greater in-depth analysis. I think I'll stop it and let the others.
Thank you, sir. Mr. Divan, coming to you. Often there are a lot of criticisms of the Supreme Court's functioning as one major thing, as Justice Chelameswar pointed out, why should it even hear a bail application? Why should it admit so many cases? But then what is often debated is the influence that the bar holds. That when a senior lawyer gets up and argues a matter before the court, it has to entertain it. And the kind of weight that the pressure that the bar brings on the bench, and it doesn't, this is also a place where we talk about diversity and all of that. And I'm going to ask the biggest name in legal practice this question, but what is the kind of influence the bar has on the bench? Like, because benches come and go, judges spend a very small time on the Supreme Court and they leave. But you are the permanent fixture of the Supreme Court of India, so to look. And it's often criticized that, that if the senior advocates would push for some change, that change might come. Do you think it's a thought that holds any weight?
Well, so I'll just respond at 2 or 3 levels. First and foremost, I think a good part of the Indian bar is that, number one, it's remained broadly, I would say, apolitical at the Supreme Court and the High Court level. I think that's a good thing. I think lawyers, despite their particular political persuasion, will appreciate a point which affects rule of law and stand up, or their profession and stand up, independent of what a particular political party may have its position. So I think that's one good part. We've remained a reasonably independent bar. I think our leadership has also been strong, and there is therefore mentoring insofar as the next generation of lawyers is concerned. I think when it comes to putting pressure in terms of individual cases, yes, you're quite right that a senior advocate or a senior practitioner, on the strength of his or her experience, is probably able to command a greater degree of respect and listening time from a bench. But I would broadly say that in the High Court I practiced, which was in the Bombay High Court, and before the Supreme Court of India, I would say that judges are very receptive to the members and encouraging to members of the junior bar as well. So in terms of the distance, you're right that judges in the Supreme Court typically are there for a period or a term of 3.5 years. If you're 4, 5, 6 years, you rise to the very top of the court. And given that background, I think they're just there, they're there for a short period. There is a natural tendency to defer or to respect what is coming from a senior advocate and to listen to them a little more carefully. I think on the point of pendency, and I think this is something which young members of the bar have to keep in view, we are going to be definitely moving towards a system of written arguments, persuasive written briefs, because with these type of numbers, 80,000 plus, there is just no way in which you're going to be able to allow oral advocacy to be endless and at the same time, deliver justice in a reasonable and swift manner. So I think we're as systems in the rest of the world also have, shift away from that oral presentation and eventually move to a system where, yes, you will have oral presentation, that's important, but a large part of it will be in writing, how to write a persuasive brief, how to analyze it in the shortest period of time. And the skill set of the bar will probably have to change. So it's a permanent institution, but I think at the end of the day, at least both in our high courts as well as in the Supreme Court, there is some degree of collaboration, dialogue, etc. But essentially, the administration of justice in our system lies with the senior judges of our constitutional courts. In theory, it's the High Court, as far as the states are concerned, but the Supreme Court as well has gradually assumed a role.
Thank you, Advocate Divan, for holding forth on that. Moving on to you, Professor Gopal. You have also started practicing at the Supreme Court now to represent certain kind of cases. But before we go to that, let me ask you, so have India, after 75 years, got its people's court? Do we have a court for the people of India, of the people of India, for the people of India?
Thank you, Leena. It's a very important question. It's a very important question. Bottom line is, I think I'd say that the Supreme Court of India is a court of the people, but a court of a very small section of people. It's a court of India's oligarchy. It's a court of India's oligarchy. And the Constitution of India was a revolt against the oligarchic system that prevails in our country, which is not my analysis. In 1930, a century ago, speaking to the first roundtable conference, Dr. Ambedkar had predicted that when the British leave India, India will be ruled by a caste oligarchy. So that's what's happened in 75 years. 75 years, we've never had a Supreme Court judge with the name Yadav. We've never had an Irava judge in the Supreme Court for 75 years. Most of the judges in the Supreme Court come from 4 communities. And they control the bar, and I have a very different view of the bar than, I call him young Mr. Divan because I've known him for many years as a brilliant young lawyer and legal thinker, and I have a lot of admiration for him and his respected late father, always on the right side of these issues, so this is nothing personal. But basically, a small set of communities control the court and the bar. In Kerala, we've just come to know that there has never been a scheduled caste registrar general of the Kerala High Court, ever. So if you look at these courts, they are being controlled by a small oligarchy, as Ambedkar predicted. And from their perspective, their job was to prevent the revolutionary intent of the Constitution from coming into effect. And they're the most successful court in the world in doing that. The court has subverted the revolutionary intent of the Constitution and has ensured that the oligarchy stays in power. That there never is a functioning justice system in this country. There never will be, as long as there is no representative court and representative bar and representative legal academy. All these are controlled by the same 3 or 4 communities. So, therefore, it's a very successful court. I don't think there is any other apex court in the world where one lawyer tweets asking why the Chief Justice of India is exploring motorcycles, fancy motorcycles, rather than attending to the business of the court. Within 2 weeks of that tweet being issued, he is convicted of contempt by the highest court in the country. And what saves him from jail is simply the fact that the oligarchy that controls the bar steps in because his father and the senior oligarchs in the bar want to protect him. I want him to be protected. I love him, admire him very much. Prashant Bhushan, I'm glad he wasn't. Personally, I suspect he would have loved to have been sent to jail. But he was protected from jail. But where else in the world can a tweet result in a direct conviction by the highest court in the country to protect the system? You can't question judges. The contempt of court has been interpreted in such a manner that you cannot question the judges. You cannot question the functioning of the court. So the Supreme Court of India in 75 years has played a counter-revolutionary role. And the delay is part of that strategy. This is not a failure, administrative failure. Everyone knows this. And I'm personally very much against the Queen's Counsel, senior advocate system. It should be abolished. It doesn't exist in the United States, for example. Everyone is a lawyer equally. And there's no reason why, as he said, some lawyers, because they're designated senior, should get more time and more attention from the court. That's undemocratic and oligarchic. The amount of attention you should get from the judiciary should depend only on the urgency of the need to secure justice and nothing else. And the judges should be proactively encouraging the lawyers to do that, rather than saying, look, you're a senior, I'll listen to you. When I was arguing the EWS case, there was one very senior advocate who argued for over an hour and a half, at the end of which a very fine Chief Justice, Justice Lalit, very gently asked him, Mr. So-and-so, what is the point you're trying to make? Right? and very politely, very gently. But he's a very eminent, very senior lawyer for whom I have a lot of respect. But I'm sure there are many young lawyers who would have made use their time more effectively. So I would say, Lena, that we are dealing with a very successful institution that has been captured. I mean, successful in the sense its original constitutional purpose has been subverted. It has been captured by an oligarchy and used for its own purposes. And the fact that 75 years down the road, the oligarchy is stronger than ever, the share of income of the bottom 50%, as Thomas Piketty's Billionaire Raj report says, has actually decreased from 1947 to today. The share of wealth of the bottom 50% has decreased. The share of and the share of the top 10% of wealth and income have increased from 47 to today. I think a lot of credit goes to the bar and bench of the Supreme Court for having ensured that this happened. Thank you very much.
Professor Gopal. Thank you, Professor Gopal. There are very few one good thing that live streaming has allowed us journalists who follow the Supreme Court of India to witness is to see how day in, day out this workload and the judges and the advocates dealing with it. And in that massive workload, to think of structural reforms, to make space for reforms in that big institution. I always often wonder that it's easy for us journalists to sit outside and say, oh, why isn't this being done like this? A new CJI would come in, bring some certain sort of reform. He leaves in 2 months, and then that is not being followed by the next one. And from inside the court, there is very often conversations of reform coming out strongly. The very few exceptions, and in that exception, Justice Chelameswar belongs to. So what has it been for you to fight for reforms inside the court? I'm not going to deeper questions with Justice Chelameswar because later in the evening today, Malayali's favorite MP, the biggest voice of Malayalam in Parliament, John Brittas, would be having a one-on-one session with Justice Chelameswar, having deeper conversation about his legacy at the Supreme Court of India. But what has it been for you fighting for reform, saying that I will not sit in a collegium meeting unless it takes minutes, unless it make public what kind of deliberations are being done there? What has it been to fight for that kind of a space at the Supreme Court of India?
Say, when you're talking about reforming the institution, and of course I carry this tag, some use it very flatteringly, some use it very derogatorily, that I have rebelled, whatever it is. Point is, Supreme Court has a dual role. One, on the judicial side, it has a specific role insofar as the nation is concerned. On the administrative side, it has a different role. And the nature of the role the administrative role kept on expanding over a period of 75 years. If you see the text of the Constitution, there is an express provision in the Constitution which says High Courts shall have superintendence over all the courts and tribunals within the territory over which they exercise jurisdiction. No parallel provision is there insofar as the Supreme Court is concerned. But over a period of 75 years, how it happened anyway, it is a great debate, you can go into all those things. Now, Supreme Court has acquired, of course, some people prefer to use the word arrogate, anyway, I may not go into it. It has today, as a matter of fact, a huge amount of supervisory jurisdiction, transferring High Court judges, deciding what a High Court should do. You know, in the sense, administrators said the High Court should do this, do that, all kinds of things are circulars are issued. And then, for taking these decisions at the High Court level, since it is vested constitutionally with a superintending jurisdiction, a system is there. The language also is different. Insofar as High Court is concerned, most of the articles which deal with the administration of the judiciary in the state, use the expression the High Court. In the context of the Supreme Court, the Chief Justice of India. Now, High Courts exercise this power. They have periodic full court meetings. There is some deliberation, whatever be the quality of the deliberation. Full court meet, judges discuss their views. There are committees dealing with areas of administration. There is an administrative committee, there is a finance committee, so on and so forth. Some kind of a democratic debate. How good the quality of the debate, I am not going into it. It all depends on the individuals who are participating there. Debate takes place. Supreme Court, no full court decision is ever taken. Now, I'll give you one example. Under the law declared by the Supreme Court in second judge's case, 1993, while considering candidates for elevation to the Supreme Court, first 5 judges are required to deliberate. The Chief Justice is required to consult his immediate 4 colleagues, 2, 3, 4, and 5. Now, for appointing a judge in the Supreme Court, 5 judges are required. For appointing a Chief Justice of a High Court, first 3 judges are sufficient. But if you want to transfer a union judge from one state to another, one High Court to another court, once again 5 is required. That is the law declared by the Supreme Court. There is a huge amount of confusion why it happened, what. I am also not going into it. But if you want any systematic approach to reform the legal system, the first thing that is required is the Supreme Court, which is exercising all these powers, must sit as a body and deliberate. And this wonderful doctrine of master of the roster is the mantra for every problem of the Indian judiciary. It has a different connotation altogether. In courts which sit unbanked, American Supreme Court, well, for every case, all the 9 judges, of course, they hear about 150 cases a year. All the 9 judges sit and decide. The question of master of the roster doesn't arise there. You may have certain other administrative functions. The Chief Justice of America is a different matter. But here, under this doctrine of master of the roster, when there is a divided court in the sense, polyvocal court, division benches, court sits in division benches, 2, 3, constitution benches, 5, 7, and so on, occasionally 5 and 7. Now occasionally. To start with, it was a regular feature. The Chief Justice has a role to choose which judge will go well. How well that power is being exercised is a different story. I don't want to go into today. But on the administrative side, at least, the court is required to sit as one body. I don't mean any offense to any individual. I had the advantage of being associated with 3 high courts. One parent high court where I practiced and became a judge. As a Chief Justice of 2 high courts, Kerala and Guwahati, I gained some experience. Now, if all this experience is worth nothing, when I go to Supreme Court and my experience as an administrator is worth nothing, only the Chief Justice of India decides, I don't think it is a system which has any hope for improvement. I may be a bad administrator. I might have been a very bad administrator in Kerala or Guwahati. I don't know. It's a matter of opinion. You can make your own decisions. But then the fact remains, I had the experience. 4.5 years I was the Chief Justice of 2 high courts. It adds some experience to me. And there is no collective discussion in the Supreme Court in these matters. And insofar as the law is concerned, I told you, while considering the names for elevation to the Supreme Court, first 5 judges, the Chief Justice is required to consult 4 judges sit next to him. It so happened, one of those days, all this appeared in the newspapers. I refused to participate in the collegium meeting. I said, please circulate, whatever is your decision, please circulate. If I agree with you, I'll say yes, otherwise no, I'll not hold it for a day. In 24 hours, I'll return the thing. Then a certain resolution was circulated to me, which indicated, it's all matter of record, Supreme Court record, which indicated that I had participated in the collegium meeting. I objected to it. Look here, I didn't participate. I object to it, I'll not sign. Then the Chief Justice writes back to me Since you refuse to sign, I expand the collegium, I'll consult the next 2 judges. Well, how are you on the administrative side? How will you tinker with the constitution bench judgment of second judge's case? It is fixed by law. And you have taken oath to protect and uphold the constitution as by law declared. And on the administrative side, I still have a copy of that letter. I have expanded the collegium, I'll consult the next 2. I mean, this kind of, I'm not trying to blame anybody today, it just makes no difference to me. I retired 7 years back. All that makes difference is whether I'm getting my monthly pension or not. That's a different story, I'm not on that. We are talking about the system. And I'm sorry to say, my dear friend, the Supreme Court bar, which the senior advocates, well, everybody regularly, the newspaper is the champion of the liberties in this country, XYZ. I'm not talking about my friend Divan. I know him. He's genuinely a champion. I have no problem about him. But quite a few. The doyen of the Indian bar is so-and-so, so-and-so. On matters like this, they never opened their mouth. They never opened their mouth. And anybody opening, when I said I'm not attending the collegium, a very eminent lawyer of this country of 20th century, perhaps one of the greatest of 20th century, he said Chelameswar would have, the country would have appreciated Chelameswar better if he had resigned and said it. When one of my peers, Justice Rumapal, said something after retirement, the same Supreme Court said, what were you doing when you were in office? When you say, talk something when you are in office, it is objectionable. When you say something after retirement, it's objectionable. What is it? What is it going on? And what kind of a reform or improvement do you expect in the system? I don't know. It requires a huge debate. And then, as I said that day in the press conference, it's ultimately, I'm sure there are lawyer friends here. There's a famous treatise on American constitutional law in 4 volumes by Joseph Story, a judge of 1830s, American Supreme Court. The last sentence in that commentary, he says, exact wording I don't remember, well, I can find out it still, I've saved it on my iPad, the book. It says, nonetheless, it's a wonderful document we have created, blah, 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 it says its defenses are impregnable. But it says, nonetheless, it may perish within an hour of the folly of its only keepers, the people. When the wise are banished from the councils and profligate are rewarded, for only they can flatter in order to betray later. It's for the society, civil society, to constantly evaluate, audit the performance of any institution in any democracy. If the civil society keeps silent, then nothing can happen. Sorry.
So, Mr. Divan, Advocate Divan, I have put you in a very very difficult position because there are 2 very strong critiques of the institution on either side of you. But your presence here also symbolizes of what you stand for. Your tone of evaluating the Supreme Court of India might be measured, but it's a carefully studied one. And you are one who still holds a lot of time in that court and whose life and career is built around that court. How do you look at this call for change at the way that the Supreme Court of India shall function? All these big criticisms, big changes that the court need to do right now, before it's way too late to fix things and before people at large stops believing that there is a Supreme Court of India that stands for them. What are the immediate measures? And I know you'll come back to me in a very measured tone, but it's a very studied tone, I understand. And how do you see that the bar can do anything about this?
Well, I don't know about the role of the bar, but I can point to at least 2 or 3 measures that can be taken which would address in some part what Mohan, Gopal mentioned and what Justice Chelameswar mentioned. The first, I think, is we definitely need much greater diversity in our constitutional courts and diversity on the Supreme Court of India. And by diversity, I mean, first of all, what's really apparent and in the face is gender diversity. I think the Supreme Court, to an extent, has a measure of regional diversity. But there are, as was mentioned, so many different facets to our society. And I think giving a voice to those different facets really improves the quality of justice. It improves, so having representation on the courts through a real big diversity push is, I think, something which would help make it more a people's court, but at the end of the day, improve the quality of the administration of justice. So that's point one. Point two, I think we tend to concentrate too much power in the Chief Justice of India and the Chief Justice of the High Courts. So it's a question of giving up power. That's always very difficult. But I think it's possible. I think it's necessary. I was hearing the other day that, even for the purposes of where these plants are located on the Supreme Court premises, it's the Chief Justice who has to sign off. I mean, the burdens of administration are bad enough and grave enough, and then we concentrate so much. So I think that's another big institutional reform which can help, and which I think will help improve, by having committees, distribution of work, the judicial work, administrative responsibilities in the high courts and the Supreme Courts, and this whole business about, the master of the roster. In certain jurisdictions, you have a random allocation of cases. But frankly, that's again a question of giving up power. So it always takes that, a special vision and to sacrifice power for a larger institutional good. The third feature I would mention is, I think for far too long, the administration of justice is left to the hands of judges. Now, the business of judges is, apart from, judging, which is their primary task, administration at a small level is okay. You had initially, as all of us recall, doctors who would administer a small clinic, a small home, etc. But now if you have large hospitals, you have a professional management. The doctors have to give up and concentrate on what they're good at. And I think the time is long overdue where, if we are going to cut down on our pendencies, for example, be more efficient, come up with a citizen's charter by which the citizen knows that on the day she presents her case in court, it's going to come up for a first hearing within so much time. It's going to come up for what we call an interim full-fledged hearing in so much time, and a final disposal in so much time. I think every citizen has a right to know that when she approaches the court or she approaches the tribunal. So I think now to move to that, you need professional administration. You need professional managers. That's again going to require an issue of giving up power. So I think these are three issues which I have placed: diversity, less concentration of power in the Chief Justice, and professional management of our courts, where I think we could then make considerable strides in our efficiency and ultimately in the delivery of justice.
As always, a very measured and studied and careful response to that. But coming to you, Professor Gopal, he has very rightly placed the solution in the hands of diversity. When last year there was a big question of why not more women judges, what D.Y. Chandrachud explained it as is there is not enough Chief Justice in the High Court that we can elevate, women Chief Justice in the High Court that we can elevate to the Supreme Court. There are people on the bar who are very eminent women lawyers who are not being elevated. And also, this other question, do we have a North Indian Supreme Court? Do South India really need a separate bench of the Supreme Court in South India to feel that they also have access to justice the same way that a Delhi or a North Indian person would have? How do you weigh on these questions?
No, I agree very much with what Justice Chelameswar and Shyam Divan said on all the points. But I'd like to continue on that. There's one important, because I had the opportunity when Justice Kapadia was the Chief Justice, he asked me the same question that you're asking, what can be done? And I suggested to him that you need an institutional mechanism. That's how the National Court Management Systems Committee was established, and he asked me to chair it. And now there's a current sitting judge of the Supreme Court who was a member of that committee earlier, is now the chair of that committee. So there is an institutional mechanism to handle this in a systematic way. There are state court management systems committees also. And I've worked with the Judicial Academy now for over, directly there and indirectly for 2 decades from the inside of the institution. So I do want to say that I am neither Justice Chelameswar or I are critics of the institution. We are only questioning whether that institution has been captured and used for purposes for which it was not intended. But the Supreme Court is the only court created by the Constitution of India. All the high courts, the lower courts were all there in the 1935 Act. There was a federal court that was abolished, and the Supreme Court is the only child of the Constitution of India. And therefore it's a very special court. It's our court. It's one of the only countries in the world where we as ordinary citizens can directly move the Supreme Court for the protection of our rights. But standing in the way is a bar and a bench, not the Supreme Court, not the Constitution. And so that potential for the Supreme Court of India to be a unique people's court, which was what was crafted by Dr. Ambedkar, is being blocked by a group of people. So we are not against the institution, we are not critiquing the institution, we are lamenting that the institution is not being allowed to breathe and function and live. So that's a general point. But the particular point I want to make is that I agree with the need for professional management. But at a policy level, the first thing is we need performance standards. And there are no performance standards. Now, how do you elevate someone as a judge of the Supreme Court or a High Court? They're doing this. They have no standards. How do you make someone a senior advocate? There are no standards. And so you find a very large spectrum of people being appointed judges, being elevated as senior advocates. I don't believe such a position should exist. So the point Justice Chelameswar said, that we must democratize the functioning of these courts. Can you defend democracy if you are not democratic internally? Can an institution that is not internally democratic defend democracy? That's the challenge we have. So one of the first requirements we have is that for democratizing, we need measurable performance standards and accountability for meeting those standards. We've created a term called quality, responsiveness, timeliness, and efficiency, QRTE, right? So what is a good judgment? What is a bad judgment? We don't have any scientific way of establishing how many judges does a court need? How many judges should the Kerala High Court have? What should be its strength? How do you measure that against the number of cases that are being filed? We look at judge population ratio. There is no correlation between judges and population. Population must file cases. There must be a correlation between cases and judges, right? Not population and judges. And therefore, how do you establish a proper number of judges you need? Now, we've done research to show that when economic development takes place, literacy improves, the number of cases filed per 1,000 population actually increases. So Kerala and Delhi and so on have much higher rates than Bihar and Uttar Pradesh. Now, why? Because there's more literacy, more awareness, people turn to court. But we are still looking at population to decide how many cases, how many judges we need. So we need performance standards. And then we need those to be transparent. We need a mechanism for accountability. We have no way of proceeding against malpractice by lawyers. And there are, I'm right now dealing with such problems. And there is no remedy against the bar or the bench. And so people are helpless in front of the judicial system. So on performance standards, the National Court Management System Committee has prepared, and that's the main work I did, a set of performance standards on all aspects, including quality, responsiveness, timeliness, efficiency. How do you measure this? Judge strength, judicial strength. And we have put these papers were prepared by committees headed by senior High Court judges, some of who are in the Supreme Court or have now come and gone from the Supreme Court. And also with professional experts in those committees, management experts and others. And these reports are online now on the Supreme Court website. But they have to be implemented. But the implementation is being resisted because ultimately there is no other apex court in the world. Right? I worked on many countries because I worked internationally. That you can walk into the Chief Justice's court or a court of a senior judge or any judge of the Supreme Court and discuss scheduling of a case. When will you hear me? Tomorrow, next week, morning, evening. That's not what an apex court does. Apex court is there to protect rights, to clarify the law that is not clear because it has not been pronounced or there are conflicting rules. So Justice Chelameswar began by saying it's chaos. But wherever there is oligarchy, there is chaos. Oligarchy and chaos are twins, inseparable, conjoined twins, because an oligarchy can only work if there's chaos. So therefore, I think implementing all this, what we need is we have now performance standards. We should implement them. This is the only country in the world where lawyers can make huge amounts of money simply to get a case admitted. Right? Not to argue the case. And I think it's immoral to ask for such money or to take such money to protect a right. I have fundamental rights to which my Supreme Court should predict, but I have to pay lakhs of rupees to senior counsel to get that court to hear it. And this immorality continues unquestioned. That is the legacy of 75 years of the Supreme Court. Thank you.
Thank you. Thank you, Professor Gopal. I think it's time to, I've many questions and many areas that are still not covered. But let me open it up to the crowd to take some questions from them. Please.
Not able to hear you, gentlemen. Take the mic.
ഞാൻ നിങ്ങൾക്ക് കൂടി വേണ്ടിയാണ് ചോദിക്കുന്നത്. 23 വർഷം പ്രാക്ടീസ് ഉള്ളൊരു ലോയറാണ് ഞാൻ. മോഹൻ ഗോപാൽ സാർ ഇവിടെ പറഞ്ഞതെല്ലാം വളരെ വലിയ സത്യങ്ങളാണ്. 2 മാസം മുമ്പ് ഞങ്ങൾ കണ്ടിരുന്നു, ഡിസ്കസ് ചെയ്തത്. അപ്പം ഞാൻ 23 വർഷം പ്രാക്ടീസുള്ള ഞാൻ അതിശയിച്ചു പോയി. അതായത് ഭരണഘടന ഉണ്ടായിട്ട് 75 വർഷമാകുന്നു. അതിൽ സമത്വം എന്ന ആശയത്തെ തുരങ്കം വെച്ചത് സുപ്രീം കോടതിയാണ്. കാരണം ഒരു ന്യൂനപക്ഷത്തിൻ്റെ കോർട്ടാണ് സുപ്രീം കോടതി. എപ്പോഴും ഒരു ന്യൂനപക്ഷം, ഒരു ബ്രാഹ്മണിക്കൽ ഒളിഗാർക്കിയുടെ ഒരു ന്യൂനപക്ഷത്തിൻ്റെ കോർട്ടാണ്. അത് മാത്രമല്ല, ഈ കൊളീജിയം സിസ്റ്റം ഇതാണ് ഈ ബ്രാഹ്മണിക്കൽ ഒളിഗാർക്കി ചൂട്ട് പിടിച്ചു കൊടുത്തിട്ടുള്ളത്. അത് നിർത്തേണ്ടതല്ലേ? എൻ്റെ ചോദ്യം ചെലമനീശ്വർ സാറിനോടാണ്.
Yeah. So he's asking that he was discussing this with Professor Gopal. He was discussing this with Professor Gopal too, that he's a lawyer with 25 years of practice. And what do you think about the collegium system that holds this oligarchy together and how it needs reform? The collegium system. He wants to know your opinion on the collegium system and how it holds this oligarchy together.
Gentlemen, see, my views on the collegium system are already on record and printed and published. I don't have anything to add today. I have not changed my views. That much I can say.
Next question.
Hi, sir. I have 2 questions. My first question is for Justice Chelameswar, sir. Actually, you had answered it. But my question was not like that. I want to ask, we had an NJAC and we striked it down, stating it is, we are having concerns on independence of the judiciary, and we reinitiated the collegium system. But the collegium system itself is having issues like transparency and delays in appointments, and we are having friction between executives. So I want to know your personal opinion on whether we should reinitiate the NJSC, which we striked it down. And my second question is for Gopal sir. Actually, I was taking notes, and you were saying about QRT on elevating judges to higher courts. Recently, we have been seeing instances like judges. I don't want to say it like name instances of like the judge of Allahabad court, his opinion under. Do you really think the functioning and conduct of the judges has to be a concern while they are in a position? Already we are having a guideline, but the civil society is facing, like, we are having doubts on the conduct and their opinions.
May I, Leena? I think Justice Chelameswar, on his views on NJSC, he has already
Yes.
dissented, and his dissent judgment is a celebrated dissent. And he stands by his own opinion, as he always does. But I just want to, before I come to you, I just want to make a point, ma'am. Leena, you had said that there is not enough female judges in the High Court. But how did they bring Justice Bela Trivedi up from being a puny judge of the High Court? So there is availability. But the question is what who is driving this is the question. But there are women judges and wonderful women lawyers. I think I wish there was a world in which Indira Jaising would have been a judge and the Chief Justice of India. She should have been. But so that's, I think the pipeline is not the issue. I wanted to respond to that. On your point, yes, I think we have the Judges Inquiry Committee. In 75 years, there have been only half a dozen or so instances of judges being held accountable, and now there is a motion to do that, and we see that happening. I've had the rare honor and privilege of actually being a member of one of these committees, of the Judges Inquiry Committee, in the case in a complaint against then sitting Chief Justice of a High Court. So I have personal direct experience of that. I think on the whole that system is a good system. I think I have direct experience of it. It is like three people nominated by Parliament, a sitting Supreme Court judge, a sitting Chief Justice of a High Court, and a so-called eminent jurist. It was in that capacity I was in that committee, come together and basically conduct like a trial. What is the evidence? We consider the evidence, and then you decide whether that person is guilty or not guilty. And if you find that the person is guilty, then the ball moves to Parliament. Parliament has the right to remove the judge. Not necessarily, they don't have to remove because the committee found them guilty. But if you find them guilty, they have the right to remove the judge. If you find them not guilty, then matter ends there. The Parliament cannot come into the picture. So this system is a good system. But the problem is that the oligarchy controls this whole thing. Because in India, actually, there are no three branches of the state. This is another myth created by the Supreme Court. There are only, for the most part, two branches of the state. Because in the Westminster model, those who control the legislature control the executive, by definition. And so there is no, like in the United States, there is no separation between legislature and executive. You must have a majority of the legislature in order to constitute the political executive. So the only institution outside that group is the judiciary. And so when the legislature plus executive decide that this judge should not be touched, there's nothing you can do. Plus you have to get 50 Rajya Sabha MPs or 100 Lok Sabha MPs in order to file a motion. Then the speaker or the vice chairman, the vice president of India have discretion to admit or not admit the motion. So it's a political blocking of accountability. That's the problem. What we need, like in other countries, is an ability to hold judges accountable to common citizens. I should be able to go to a tribunal that I have confidence in and make a complaint, and that complaint should be fair to the judge, it should be fair to me, it should be fair to all concerned, and that should should result in a commensurate action. That is why we talked of Prashant Bhushan earlier. They have a group that works on judicial accountability, and they've been pressing for reforms. But again, it's not in the interest of the bar to create these reforms, because then their control gets reduced. At the Supreme Court, the dominant force is the bar, because as Shyam said, the judges come for very short periods of time. It's the registry and the bar that really run the Supreme Court and hold the real power in the Supreme Court de facto. So I think we need accountability. We do not have judicial accountability. We need to abolish criminal contempt of court and say there should be only civil contempt where you obstruct the court. In other countries in the world, if I defame a judge, the judge has to file a defamation suit in a court of law like any of us. That also ensures that those courts work well, because the judge's remedy is to go to a court of law. But when a serious allegation was made against the sitting Chief Justice of India by a staff member of the Supreme Court, then what did we do? There was no accountability. The matter was closed by the Supreme Court. But why? Because obviously the Supreme Court the people who were in control of the Supreme Court did not have faith in the Indian judiciary, because the Chief Justice of India should have presented himself before the Indian judiciary so that the magistrate would have protected his rights and ensured that he is not, he's not subjected to false allegations. But why did that case not go like an ordinary defamation case before a district court judge? Because those individuals concerned did not have faith in those courts, those judges of their own courts. Whereas I've written an article on this in America, in the UK, in Australia, when similar allegations were made against very senior judges, they had to go before a trial court judge and face those allegations and get acquitted or convicted. So ultimately, those who control the judiciary must build a system in which they have faith. When Judge Loya died, the matter was closed without a proper investigation. By who? By the police, but under whose supervision? The judiciary supervision. So why did the judiciary not have faith in having that investigation? So we should have a judicial system where they have faith in themselves. And we should be able to hold them accountable if they have to improve their quality. Then our vigilance is the best assurance of the integrity and quality of the judiciary. They must give us the opportunity to hold them accountable.
I have two questions. The first one is, what's your take on judges accepting other constitutional positions after retirement, like being the governor in a state? So can you blame us if you think that judges are acting according to the interest of the ruling party for being in their good list? So that is one question. And the second question is, what is so difficult for the judges in the Supreme Court to understand that marital rape is a crime? Isn't it very basic? That's the second question.
No,
Before Professor answers the question, I am not answering the question, only one answer. Ma'am, you are still in bygone era. Former judges of the Supreme Court accepting governorships. Former chief justices are accepting TTD board membership also nowadays, if you don't know that. TTD is Tirumala Tirupati Devasthanam. The governing body is appointed by the state government. One of the former chief justices of India is now a member of that.
So no, I think all of us here would agree that, to quote Arun Jaitley, not a source I normally quote, but pre-retirement appointment judgments should not be driven by post-retirement appointments. The pre-retirement judgments, should not drive. Same thing. Yeah. So no, the same thing, that pre-retirement judgments should not be influenced by post-retirement appointments. And I think there's no doubt that should not happen. And he is an outstanding example. I think he deserves a round of applause, who has absolutely stayed away from post-retirement appointments. So we know his pre-retirement judgments were safe from such considerations. I know that even before he retired, that he had very clear in his mind. Much before he retired, I know him from when he was a puisne judge in the Andhra Pradesh High Court. He was very clear in his mind that he will never. Similarly, yes, but very clear in his mind that I will never accept anything. Justice Madan Lokur, Justice Akhil Qureshi, all of them are very clear from the very beginning that they will never accept an appointment. Justice Kurian Joseph, all of these people. So I think that's wrong. They accept it's wrong. But there are people who don't think it's wrong. So what can we do? But we need a law against it. But why should the executive and the legislature, when all the oligarchs are running this country together, why would they make such a law? So on the marital rape, the same, rape is rape. In fact, it's very sad to read in the Indian Penal Code now, Bharatiya Nyaya, they refer to the exemption, it refers to the spouse as a raped woman. That it shall not be a crime. So there is absolutely now, it is a crime. Rape is a crime, doesn't matter who it happens to. Will the legislature and the judiciary wake up to that? That is a question. We have to wake them up.
Next question.
Sir, India being a so-called biggest political democracy in the world. See, we know there are many democracies in the world, but is there in any democratic country the judges are appointed by judges themselves? This is a very, very strange situation in India. Why it happens? India being a politically democratic country, how can the judges appoint themselves? What is the constitutionality of this collegium affair? Is there any connection with the Indian Constitution?
Mr. Shamsuddin, I take your point, but when I've studied this matter for 75-year period, right? There is no real difference between the oligarchic control pre-collegium and post-collegium. The oligarchy will control. You make collegium, you make NJAC, they will appoint who they want. So I think we are under the impression that the collegium system is somehow altering the nature of the judicial appointments. Unfortunately, it is not. And so we have to democratize the legal academy first. We have to democratize the bar. And then you'll find that there is democratization of the judiciary. So what we must demand is, and ask and question is there representation, to quote Dr. Ambedkar, due and adequate representation of all communities in the law classroom, in the legal academy, at all levels of the judiciary, right? And in the bar. I was arguing the EWS case. On both sides, bench and bar, I can hardly find any SC, ST or OBC. This is all a bunch of oligarchs arguing with each other about whether there should be a reservation or not. The matter was dead in the water. Right? So the only solution is we have to be vigilant about and demand the law classroom. If you go to courts of this country, if you go to the jails of this country, you will find they're full of scheduled castes, scheduled tribes and minorities, mainly Muslims. But you go to the law classroom, you find only a small number of them. You go to the faculty, you find very few of them. You go to the bar, you will find very little representation amongst those who are actually handling the cases. The vast majority of advocates are from a SC, ST, OBC background, but they will not have any work. Because people want to engage lawyers who will be able to command the time and attention of judges. And so they will only listen to certain kinds of lawyers. So they will get the briefs. So you will find that amongst the lawyers who command the briefs, there is very little representation of SC, ST or minorities. And so, and this is a vicious circle, because if you have no representation in the judiciary, then clients will not give lawyers briefs except mirroring the representation in the judiciary. So ultimately, we the people, first three words of the Constitution, we the people, we have to fight for this. That's what Dr. Ambedkar told us from the very beginning. The problem is the oligarchy, the solution is representation, representative democracy. We've neglected that. It's been undermined and sidelined, the issue of representation. But we have to demand, and at all levels, this is not a simple issue of collegium. Then the collegium will become irrelevant. The collegium, actually, what is the caste system? It is the social collegium. Categories 1, 2, 3, 4 are running the country. That's a collegium of the whole country. 4 categories, category 1, 2, 3, 4, they're running the country. So they're just extending the collegium concept to the judicial appointments. But we need democratization.
Can I add a
Yes.
question to that, Advocate Divan, if I may ask you? Bringing representation in has been a long, efforts going on, and there is nothing happening. But to the people who have the most enviable practices at the Supreme Court, when you recruit your juniors, do you ensure that there is representation among them, that you give opportunities to someone from the most backward areas, that you give opportunity to someone whom you see a spark, but without the kind of belief that you put them would not be able to come forward? Would you, in your institution, in the people that you mentor, try to ensure that there is diversity and representation? Is that possible at a personal level for you?
I suppose it is certainly possible, but the kind of chamber that I have is a very small, fragment in terms of, it's not a large office or any of that. So it's often people, you meet in the corridor in the Supreme Court, some junior comes and says that I was working with ex-judge as a clerk, may I please join, etc. So those are the considerations. But I think the primary consideration, at least which I learned when I joined the bar, was that if you have a space in your office, whoever it be who comes up, you have to assist him or her in joining the bar. But I think there's, the point which you make is something which we could definitely work on in terms of increasing diversity and representation in chambers. But just speaking to that question about democratization, I should just mention of the appointment process. Perhaps all of you know about the developments which are taking place in Mexico. And in Mexico, there's been such an extraordinary pushback that each and every appointed judge has now to stand for election. So 50% of them will be standing in 2025, and the remaining half will be standing in 2026. So it's like it's the other extreme. And at least insofar as both the judges as well as members of the bar are concerned, there is a considerable degree of agitation because they just feel that what they're likely to have is not something which is as good, or it's likely to be something worse than what they already have. Also, in certain jurisdictions, such as Israel, for example, the judicial wing has a considerable say in terms of appointment of judges to their constitutional courts. And then there are other models which are followed across the world. So, for example, in Germany, to be on the constitutional court in the German constitutional court, there are so many checks and balances. You need permissions and consent from so many authorities that it's only the people who are middle of the road who get appointed to the German constitutional court. You will not have someone from an extreme point of view at all. But that's, because of the history which they have had and the difficulty which they experienced, less than 8 decades ago. So that's the experience over there. So I think as far as the collegium system is concerned, if we are to move on as we will, what is new shouldn't be worse than what we already have. I think that's the bottom line. To some extent, of course, you wouldn't know that unless you actually make a trial of that new system.
Lena, with your permission, can I just add something while agreeing with him that India is in a very unique situation where I've been arguing for the last 2-3 years there is a group that is trying to establish a theocratic Hindu Rashtra for which they have to overthrow the constitution. And that group, which has been for a century saying, we want a Hindu Rashtra here, a theocracy in this country, they have captured power now. They are appointing judges. And those judges are sincerely, not for any post appointment position, but out of their own conviction, sincerely, they believe that India should be a Hindu Rashtra. And they are engaging, producing what I call theocratic judging, where the highest principles are drawn from religion and not from the constitution. And we've seen the Ayodhya judgment, Gyan Vyapi mosque and all that. So that is the real threat now. That the judiciary is leading the way for establishing a theocratic Hindu Rashtra in the country. How do we counter that? There I agree that at least for a period of time, the existence of the collegium, where there are still judges who are absolutely rigorous and committed to the constitution and committed to looking at the judiciary as a defender of the constitution, a few of them are in the collegium. So Justice Rohinton Nariman, for example, blocked all appointments to the Supreme Court because Akhil Qureshi was not being elevated to the Supreme Court. He stopped everything. He said, no, I'm not going to clear anything, appoint Akhil Qureshi. And they refused to appoint Akhil Qureshi. They preferred to leave the vacancies in the Supreme Court rather than send Akhil Qureshi there. Right? So there are still some voices that will protect the Constitution through the collegium system. But as we have now seen with the appointment of the National Human Rights Commission chairperson, we have seen how that's how NJSC would have worked. That there is an opposition person there who's given 700 names and 5 minutes to apply their mind, and the government has a majority. They just push it through and appoint whoever they want. So right now, although I'm not a fan of the collegium system, as so long as we have the possibility of having some person who is committed to the constitution to have a role in appointing judges, I think that's a safeguard which we should not throw away for now. So I'm now not in favor of changing the collegium system at this point.
I may add just one thing. That gentleman asked about system of appointing judges by judges. Sir, I must tell you, it's all an illusion created now as of today for the last 20 years. As Professor Mohan Gopal was mentioned a name, Justice Rohinton Nariman, he was inside. What happened? No collegium meeting was held until he retired. The master of the roster didn't hold a collegium meeting. And why did he do it? Because the appointing authority is somebody else. And when they don't want to appoint, I'm not talking about political party. This party, every political party behaves like this. When they don't want to appoint somebody, the recommendation reaches the government and the government sits on the recommendation. When they want to appoint somebody who is not recommended, well, there are other ways of getting things done. So therefore, don't think that judges are appointing judges always. Finally, it is the political power. Now, somebody asked me about my views. That's why I never said change the collegium system. But then the new experiment, a representation by public personalities, the civil society in the NJSC, that is something welcome. There can be some kind of a check on the arbitrary excess of the power by the members of the collegium. Unfortunately, majority didn't agree. That's a different matter. But even after that, how many appointments were stalled by the government after the recommendation? They never came through. So therefore, don't think only judges are appointing judges.
ഒരു ചോദ്യം. ഞാനൊരു പൊളിറ്റിക്കൽ ഓർഗനൈസേഷൻ്റെ പ്രവർത്തകനാണ്. എനിക്ക് എല്ലാവരോടും കൂടിയാണ് ഒരു ചോദ്യം ചോദിക്കാനുള്ളത്. UAPA എന്ന നിയമത്തെക്കുറിച്ചാണ് എനിക്ക് ചോദിക്കാനുള്ളത്. പ്രത്യേകിച്ച് ജസ്റ്റിസ് ചെലമേശ്വറിനോട് അതിൻ്റെ ഉത്തരം ആഗ്രഹിക്കുന്നു. നിലവിൽ പോസ്റ്ററുകളും ലഘുലേഖകളും വിതരണം ചെയ്തതിൻ്റെ പേരിൽ മാത്രം 12 UAPA കേസുകൾ രജിസ്റ്റർ ചെയ്യപ്പെട്ട ഒരാളാണ് ഞാൻ കേരളത്തിൽ. ഇത് കേരളത്തിന് അകത്തും കേരളത്തിന് പുറത്തും വ്യാപകമായി UAPA കേസുകൾ ചുമത്തപ്പെട്ട് ആളുകൾ തടവിലാക്കപ്പെടുന്നു. ഇവിടെ ആശയപ്രചരണ സ്വാതന്ത്ര്യത്തിൻ്റെ അടിസ്ഥാനത്തിൽ ഞങ്ങൾ ഏർപ്പെട്ട ഒരു കാര്യത്തിന് ഞങ്ങൾ ജയിൽവാസം അനുഭവിക്കേണ്ടി വന്നിട്ടുണ്ട്. ഒട്ടേറെ ആളുകൾ തടവിലാക്കപ്പെട്ട് കേരളത്തിലെ അതിസുരക്ഷാ ജയിലിലടക്കം, ഇപ്പോൾ വിയൂർ അതിസുരക്ഷാ ജയിലിലടക്കം ഒട്ടേറെ രാഷ്ട്രീയ തടവുകാർ കഴിയുകയാണ്. ഇപ്പോൾ UAPA സംബന്ധിച്ച് ഉയർന്നു വന്നിട്ടുള്ള വാദഗതികളിൽ പ്രധാനമായിട്ടും UAPAയുടെ ദുരുപയോഗമാണ് പ്രശ്നം എന്ന് പറയുന്ന ഒരു വിഭാഗമുണ്ട്. UAPA എന്ന നിയമം തന്നെ പ്രശ്നമാണ്, അത് റിപ്പീൽ ചെയ്യണമെന്ന് ആവശ്യപ്പെടുന്ന വിഭാഗങ്ങളുമുണ്ട്. ഈ കാര്യത്തിൽ എന്താണ് അങ്ങയുടെ നിലപാട്, നിങ്ങളുടെ നിലപാട് എന്നാണ് അറിയാനുള്ളത്.
Justice Chelameswar, this is for you. He wants to know your views on the UAPA, whether the law itself is bad or if the way it is being used is what should be restricted, is his question.
See, I understand the question, whether the law is bad or whether there is something wrong with the way law is being implemented. Is it the right question? I understood it right? He's right, sir. That question I can't answer it. The point is this. I do not. Law is ultimately something made by the people whom we have chosen, the representatives of the people. No, in a given case, even that law made by the people's representatives might be constitutionally wrong. That's one aspect of the matter. But that act has already passed muster. If I remember right, it was upheld. That's not going. We have to work in a system. Question is, when the law is not even-handedly implemented, selectively applied, then all the trouble starts. On the lighter vein, I'll tell you something. Just about 10 days back, some unfortunate incident took place in Hyderabad city. A new movie was released and the particular hero went to see the movie. There was a stampede, somebody died, something happened. A criminal case was registered against the man, he was arrested. Bail application was moved, he was released the next day. Somebody sent me a WhatsApp message. So-and-so, I'm not taking the name, so-and-so, charged, arrested, sent to prison and released in 24 hours. Who says Indian legal system is slow? Only thing is you are poor, therefore you don't get it. That's the answer.
I think with that we'll have to wind up the session.
Elena, can I just
Sure.
on this UAPA, since he asked, and he asked all of us to say something. So if you have anything, you should also say. I'll yield to you first, and then no. I just wanted to say this very briefly, that this is one example of how the liberty and freedom given to me by my constitution is being taken away from me by very narrow interpretation of my rights, where the state and its security is being given much more importance than my freedom. And so there is a very narrow interpretation of freedom by the judges and the lawyers who are running the system. But the Constitution and its intent was to protect our freedom and liberty. So I think the problem is the way that liberty has been interpreted by the Supreme Court over the last 75 years in order to narrow the freedoms given to us by our Constitution. That's the core issue as far as I see it.
Well, I'll just make one supplementary point on these very harsh and draconian laws like UAPA. And I think my observation would be, more as a citizen than as a lawyer, is that our investigating agencies have just not been able to keep up with the times in terms of their capacity to solve a crime. The result of that has been two sets of terrible provisions which are now unfortunately passing muster in our constitutional courts. The first is reversing the burden of proof, and the second is a presumption that you're not entitled to bail unless you meet some extremely high thresholds. So I think if we are able to eventually invest as a society in improved investigation and solving the crime, we will probably see a retreat in terms of these type of laws. Unless we make that investment as a society, I fear we are going to have such provisions which will continue to linger.
I'll wind up the session with a prayer that the Supreme Court of India finds a way to reform itself before it loses many more Akhil Qureshis and Justice Muralidhar, and loses some of the brilliant judges from coming to be at the Supreme Court of India. And let those reforms come fast and soon before the people lose its faith in the biggest constitutional court of the country. Thank you very much, Professor Gopal, Advocate Divan, and Justice Chelameswar, for being and blessing the grounds of WLF with your conversations. Thank you so much.